Good day, ladies and gentlemen, and welcome to the Inner Workings conference call. At this time, all participants are in a listen-only mode. If anyone should require operator assistance, please press star then the 0 key on your touch-tone telephone. As a reminder, this call may be recorded. I would now like to introduce your host for today's conference, Kristen Martin. Ma'am, you may begin.
Thank you. On behalf of Foley and Lardner, we would like to thank you all for participating in our Inner Workings web conference series. Today's conference will last 90 minutes. During this time, you may submit questions by selecting the Q&A button and typing in your question. We will attempt to answer your questions. However, if we run out of time, we will follow up with you individually after the conference. If you would like to print or save a copy of the PowerPoint presentation, you may do so by selecting the printer icon at the bottom right-hand corner of the screen. Please note that a replay and materials from this presentation will be available later in the week at foley.com/IW. Finally, if you are participating from one terminal with a group of individuals, please note for CLE and HRCI credit that you all must be logged in individually. I would now like to introduce you to your speakers for today. We have Bud Bobber and Carmen Cowden from Foley's Labor and Employment Law Practice. Bud, you may begin.
Thank you, Kristen. I am very pleased to be here and especially glad to be joined by my esteemed colleague, Carmen Cowden. Carmen, are you on?
I am. Good morning, everyone.
We're almost like a married couple in the sense that here we are probably like 20 feet down the hall from each other, but sitting in separate rooms on separate phones. But we decided to split up the opportunity to cover these issues with you, and in the hopes that we both could bring some different perspective to bear on it and save you from hearing the same voice for upwards of 90 minutes. It is my plan to conclude in less than 90 minutes because we're in the Central Time Zone and it's lunchtime. So we're going to proceed as efficiently as we can. We're really glad, though, to have this opportunity to address this topic about military veterans' employment law rights and issues. It feels near and dear to me, although I am not a military veteran. I have enjoyed a wonderful life filled with great opportunities thanks to military veterans, and I think any attention that we pay to their circumstances and their rights is time well spent, and particularly for our employer clients, because there are some unique issues relating to the rights of military veterans that employers need to know. And today we're going to touch on those, covering the USERRA law, the military leave law, the provisions of the FMLA that relate to protected leave in relation to military service. We're going to make some comments about the Americans with Disabilities Act, particularly in light of the fact that it was amended in 2009 with new EEOC regs issued just last May, interpreting the amended act, and really the upshot of the amendment of the act was to significantly broaden its scope and reach in terms of the types of conditions that are covered as disabilities under the act, and therefore trigger all of the employer's obligations under the act: reasonable accommodations, non-discrimination, non-retaliation, and the like. Before we dive into those federal laws, I want to at least make everybody aware that some states also have in their state employment discrimination law, whether it's called a Fair Employment Act or a Human Rights Act or some such thing, address as a protected status military service. And in particular, New York, Ohio, Michigan, Washington, and my home state here in Wisconsin all have military service as a protected status in their state employment discrimination law. And so some of the very same considerations apply to that protected status as would apply to the real traditional protected statuses, like someone's race or gender, religion, etc. And if you're an employer in any of those states, you should be aware of that state law and familiarize yourself with that so you remain compliant with that in addition to the federal laws that we're going to talk about. As we thought about the presentation, we did some data analysis just to see what was the state of affairs, so to speak, in terms of the employment of military veterans. And the first data point that caught me by some surprise, but I thought worth mentioning, was that the unemployment rate for veterans last year, and this is veterans from all periods of service, Vietnam era and earlier than that, all the way up to the present. But taken in the aggregate, the veteran unemployment rate was reported by the Department of Labor as slightly lower than the unemployment rate for non-veterans in 2011. But then there were a couple of contrary data points that did cause some concern. The joblessness rate for Gulf War II veterans, it's up to 12%, and it seems to be a trend that's gone up in the last couple of years. And particularly hard hit in the employment law world seem to be the male veterans in the age group 18 to 24, and their unemployment rate shown at about 22% for 2010, the last year that data was available. One other statistic reported by the federal government that bears some mention is that the federal government reports that 25% of Gulf War II veterans report having some service-connected disability, and of course, that becomes very important for employers to be aware of in light of our expanded ADA coverage. I'd like to make a couple of comments before we get into the detail of the federal law issues, and that maybe may be more policy related than law related. I was impressed by some argument that I heard from an officer in the Army who articulated a variety of bases that he argued were really good reasons for employers to focus specifically on hiring veterans. And the idea basically being you can get the benefit of some really terrific training and character building that many times some young adult has gone through in the military service that his or her peers who didn't go through the military service just wouldn't reflect, and it's things that we would all hope and expect to see from our veterans that the Army captain talked about: leadership, teamwork, performance under pressure, a real sense for those who have gone overseas and worked with folks in other cultures, a real sense of the full global economy, and these other attributes that are no doubt more or less true to some different degree in different individuals. But I think the themes bear some considerations for employers as they consider whether to make an affirmative effort to reach out and hire veterans. And as we thought further in preparation of our presentation about that topic, one thing that occurred to me was that businesses have a real opportunity here to do something particularly good, that is some focused hiring effort on employing military veterans and achieving some of the benefits of that training and character building that they've already experienced. But in addition to that, it seemed to me that some businesses could really leverage that strategy in a real public relations type of manner. And depending on whether it's a consumer products business or maybe a federal contractor or other types of businesses might see some real value. And I thought that would be useful to plant the seeds of of our participants on this webinar, and we started putting this together several weeks ago. And lo and behold, last week, I see reported in the national media that General Electric announced it's hiring our Heroes project. They're going to hire 5,000 veterans over the next 5 years, and the national media picked up on that, and from my perspective, at least, and my read on it, is that General Electric enjoyed some absolutely invaluable advertising and public relations goodwill, and on a topic that there's really few, if any, contrarians. You know, if you announced a hiring project that targeted other types of groups, inevitably somebody not in that group may raise a complaint about that, and from my perspective at least, my opinion at least, it's really hard for non-veterans to raise any credible and legitimate complaint about an employer that says it would like to focus some of its hiring effort on hiring veterans. In some of the same media reports about the GE project, I noticed that the American Legion was reporting that other employers also have rolled out some specific targeted hiring projects relating to military veterans, Humana Prudential, Home Depot, Target, Walmart. And I don't know the details of all of those. That's just been reported in the mainstream media. But the point I thought worth making was that it seems to me some very sophisticated employers, and who also have some very sophisticated marketing strategies, have identified veteran hiring projects as a real positive thing to do. And I think that tells all of us who are employers that it's something worth considering for our own companies. But in addition to some of those maybe philosophical reasons for hiring veterans, the federal government has also created some real economic ones, and I'll ask Carmen to speak to those.
Thanks, Bud. Again, these are some tax incentives that we're going to talk about that are available for employers who are hiring veterans. Typically, these tax credits are out there for employers who are hiring veterans who have been unemployed for some longer periods of time. Again, we've got sort of some basic details about these various tax credits. You'll certainly want to, if you think these might be applicable to some of the employees that you're hiring, you'll want to talk with your tax advisor or tax attorney about whether, in fact, these tax credits will apply to you. But we wanted to at least give you the information and let you know what is out there. So the first one that's out there and available potentially for employers to take advantage of is the Returning Heroes tax credit. This particular tax credit gives a credit of up to $2,400 to employers who are hiring veterans who have been unemployed for at least 4 weeks but less than 6 months. The credit is increased to $5,600 for employers who are hiring veterans who have been unemployed for at least 6 months. As of right now, the tax credits are scheduled to expire. These particular ones are scheduled to expire at the end of 2012, but we'll wait and see if those, in fact, get extended. A couple of additional credits that are available for employers who are hiring veterans with service-connected disabilities. The first one is the Work Opportunity Tax Credit. This provides for a credit of up to $4,800 for employers who are hiring veterans with service-connected disabilities. There are some additional parameters that apply to the Work Opportunity Tax Credit. Basically, you have to be hiring a veteran with a service-connected disability who is within 1 year of their discharge from the military, or who has been unemployed for at least 6 of the last 12 months. Beyond that Work Opportunity Tax Credit, there is the Wounded Warrior Tax Credit. This credit essentially replaces the work opportunity tax credit if you're dealing with hires of longer-term unemployed disabled veterans. The Wounded Warrior Tax Credit provides for a credit of up to $9,600 for employers who are hiring veterans with a service-connected disability who have been unemployed for at least 6 months. Again, these same tax credits are right now scheduled to expire at the end of 2012, but we'll wait and see if they get extended any further. Just a couple of notes before we move on to the actual military leave law. In addition to these federal tax credit programs, there are a number of states that have state-specific programs that allow employers to claim some kind of credit, either in the form of a tax credit like what we're seeing here under federal law, or sometimes they're allowed to claim a credit for a certain portion of the wages that they ultimately pay to a veteran who they've hired. So again, those are some things that if you're hiring veterans or looking to hire veterans in your workforce, you may want to look into and find out if it potentially applies to you. And with that, I'll turn it back to Bud to talk a little bit about USERRA.
Well, I'll be happy to split that up with you, Carmen, but I'll start. We want to give a general overview of the military leave law. This is the federal law, Uniformed Services Employment Reemployment Rights Act. Essentially, USERRA prohibits discriminating against somebody because they perform service in one of our uniformed services. And think broadly about that. That's, not just people who were drafted in the old days, so to speak, but this includes volunteers. It's active duty and reserve duty. It's other types of uniformed service as well. And you shouldn't have presumptions about this, that, or the other type of military service that wouldn't trigger these job protection leave type of rights. This is broadly applied. And USERRA gives the individual the right to be reemployed and some continued health care and pension coverage while they are out on military leave. It's important for employers to understand this right now because our country is thankfully experiencing the return of many service persons who will be assimilating hopefully back into the workforce sooner rather than later, and some of these may be your employees who come back and have a right to be reemployed. So we're going to talk about USERRA kind of almost chronologically from the beginning through the return of a military leave situation. And first of all, let's just start with who it covers. And as we mentioned earlier, active reserve members, the National Guard, when they're engaged under federal authority, which I suppose is slightly different than if a governor of a state calls out for the National Guard and there's a state law action. But under federal authority, anybody serving in the National Guard is covered under USERRA. I was interested to learn, quite frankly, that individuals who leave your workplace to go attend one of the military service academies, West Point or one of the other ones, Air Force Academy in Colorado Springs, for example, are considered covered by USERRA, and they'll have reemployment rights under USERRA. And again, the point of voluntary, involuntary service doesn't matter. Even with people that have elected to perform military service, they're covered by USERRA, and I think some uninformed employers may sometimes think otherwise. Well, that's your choice to go off and do the service. We're not going to be able to hold your job for you. Well, you have to under the USERRA obligations. And so start to finish, here's how it kind of works. On the front end, the individual has to give the employer some notification that the individual needs to leave work for a while to go perform service. Now, unlike FMLA and some other notice requirements that we see in the employment laws, there's no specific form of notice that satisfies the USERRA notice provision. It doesn't even have to be in writing. You know, the individual can go up to his or her manager and say, you know, starting in May, I'm going to be off on duty, and that's going to be enough. The employer can require written notice of the leave if the leave is going to last for more than 30 days, so it's not just the 2-week reserve duty type of thing, and then you can ask to have that confirmed in writing. The employer is not entitled to refuse the leave or put any conditions on it based on the argument that you know, that's really a hardship to us. We can't hold your job open, or we can't accommodate, so to speak. We can't accommodate your absence for that period of time. We're obligated under our federal law to make that work. And yes, there are certainly circumstances where the hiring of a temporary replacement or the training of someone to fill in for the absent service person is going to cost the employer additional dollars in one way or another. That's just the reality of compliance with the law. And employers should not be pushing back on military leave requests based on some level of inconvenience to the company. Okay, so after the employee has given the notice and headed out on leave, USERRA protects some of their rights while they are out on leave. For one thing, the individual is entitled to the same non-seniority rights that other people get when they're out on leave, unless, of course, they wrote you a letter and said, I've decided I'm going to, stay here overseas and I'm never coming back to the job. Thank you for everything. If they give you that notice, then they're not entitled to these ongoing benefits. But an example of this might be a year-end profit-sharing bonus, and if somebody out on a couple of weeks of medical leave in January is entitled to share in the last year's profit-sharing bonus, then somebody out on military leave also is entitled to the benefit that is extended to other people, even if they're on leave. And so you think of it in those terms. You know, the fact that it's a military leave compared to a different type of leave can't inure to the detriment of the employee. They're entitled to the same benefits. On health care, the employee is entitled to continue with existing coverage under your health care plan for up to 24 months or their period of service, whichever is less. And I really recommend that employers open up a dialogue and talk with their employee going out on military service leave about this issue, because in many instances the employee may get health insurance coverage through the military service and won't want to continue coverage under your health plan, especially because after 30 days you can charge, if you want to, you're certainly not required to, but you have a right to as an employer, charge essentially what looks like a COBRA rate for continued coverage, 102% of the total premium for the coverage if the person out on military leave wants to continue it beyond 30 days. Now, if it's a military leave of less than 30 days, you just apply your regular premium share that you would have been applying to that employee had he or she stayed at work and not gone out on leave. The real interesting stuff to me about USERRA comes next, though, when the individual comes off of leave and USERRA creates reemployment rights. And because that's more complicated, I'll ask Carmen to cover it.
Thanks, Bud. As Bud said, reemployment, I think, is one of the trickiest areas for employers to deal with. And in part, I think that's because with so many other employment laws, the issue is to make sure that you're treating the person in the protected category the same as you would treat anybody else. And reemployment under USERRA actually gives returning veterans a little bit of a bump. It provides that you have to do certain things even if you otherwise wouldn't generally do it for non-veterans. And so from that perspective, it's one of those tricky areas for employers to navigate because it's a little bit outside of what they're normally thinking about. With respect to reemployment, in general, the whole purpose of USERRA's reemployment provisions is to restore the returning veteran employee to the same job he or she would have held had he or she not gone into the military service. What this means is that if you have had someone who's gone for a longer period of time, say a year or more, you may have already hired someone to replace that employee. Either you've filled in with a temporary employee or you've just hired some more permanent long-term replacement for that individual. USERRA requires that you terminate the replacement, whether they be temporary or whether they were hired for a more permanent position with the company. If that returning veteran wants to come back to work, USERRA is going to require you to terminate the replacement. There are, a few conditions that will allow an employer to sort of fall outside the requirement that they have to reemploy a returning veteran. There is a 5-year leave limit. Once a veteran is off work for 5 years, potentially the employer might be entitled to deny them reemployment. However, employers need to be really, really careful with this 5-year leave limit because it's not a hard and fast rule. It's not always going to be a 5-year cutoff. The law and the implementing regulations provide for all kinds of circumstances where that 5-year leave limit is going to be extended. One of the most obvious examples is when you have an individual who sustains some kind of injury as part of their service and they need some time to recuperate or to heal from that injury. That is one circumstance where the 5-year leave limit will be extended, and there are lots of others. So if you're ever dealing with a situation where you're bumping up against that 5-year leave limit, you probably want to reach out, double-check the regulations and the law to make sure that it really is a situation where you can go ahead and apply that 5-year leave limit and the other exceptions or the other extension situations don't apply. Another thing that will allow an employer to fall outside of the requirement that they reemploy a returning veteran is if that veteran was dishonorably discharged. The returning veteran has to have an honorable discharge or they're not entitled to reemployment with their prior employer. In addition, the returning veteran has to make a timely application for reemployment. Timely application is going to vary based upon the individual circumstances involved with the leave, and primarily it's going to vary based upon how long the veteran is off and involved in the service. You'll see here on the slide there's a couple of different time frames that apply. If you have a veteran or an individual in the military who's gone for less than 31 days of service, in order for them to have timely applied for reemployment, they have to report to work at the beginning of their next first regularly scheduled work day. Now, there are some sort of rest periods built in there to allow for example, if someone's got to travel or if they work on first shift but didn't finish with a training until sometime on third shift, they have to be allowed a reasonable period of time to sleep and to travel to their work. But for the most part, they're expected to report to work at the beginning of their next regularly scheduled workday. If the period of service extends for a little bit longer and you start to fall, and they fall into the 31 to 180 days of service, then a timely application for reemployment is required within 14 days of the end of their service. If you go longer than that and the service extends more than 180 days, then the returning service member is given 90 days after the completion of service to reapply for employment. Again, much like the 5-year overall limit for reemployment, these application periods get extended for individuals who are hospitalized or who are rehabilitating or recovering from injuries that they either incurred or they aggravated while serving. One thing to note about reemployment rights, you heard Bud mention earlier that an employee or a returning service member can essentially waive their right to non-seniority benefits if they say they're not going to come back, if they provide notice that they're not going to come back. Reemployment is not one of those things that they can waive, even if they're providing you beforehand a notice of intent not to return. Anybody who does that still maintains their right to ask for reemployment once they come back. They can't waive it in advance. And then sort of to this last point here, if there is not timely application for reemployment, again, you don't have an automatic cutoff. What happens at that point is the employer's regular rules and policies regarding absences apply. So, for example, if the employer has some kind of point system where an individual is allowed to normally have, up to, 7 days of absences before they're terminated, then you would allow the person to exhaust the application period, and then you would start assessing them points for each day of absence after that application period. If they get to the 7 days that's provided for in the policy, at that point, then you can go ahead and you can count them out as far as reemployment goes. But you do have to give them that additional time that's available under your normal attendance rules and policies. So then the next tricky area when it comes to reemployment, which reemployment position does the person get when they return? The general rule, of course, is the escalator position. This is going to be that job that the returning service member would have had with reasonable certainty had they not gone into the service. There are regulations that talk about what it means to be reasonably certain that the service member would have had the job. To be reasonably certain, the employee has to demonstrate that there's a high probability that they would have been in or received the job if they had continued employment with the employer and not gone into the service. If you get into those longer-term leave situations where you have service of 91 days or more, employers have an additional option as far as the reemployment position that they can bring somebody back into. They can either bring the person back into their escalator position, or they can bring them back into a job of like seniority, status, and pay. Like pay, of course, is fairly simple to understand. They have to come back at the same salary and compensation rate that they had when they left or that they would have attained but for the service. What gets a little bit trickier is the status. Status can involve things like the location of the job. So for example, a particular plant location. It includes things like the shift that the person was working. If they were on first shift, it's not a job of equivalent status to bring them back in the same job but on third shift. status also includes things like opportunities for advancement. So if they were a supervisor when they left and they had the opportunity to move up in the chain of command, and you bring them back into a supervisory position that doesn't have that same opportunity for advancement, potentially that is not a job with the same status. So again, you have to be real careful when you're bringing folks back to work that you're assessing each of these things, that they're coming back at the same seniority, they're coming back at the same rate of compensation, and most importantly, they're coming back in that same type of status that they had when they were leaving. That's something that causes an awful lot of difficulty for employers when they're trying to determine which position to return a person to. And then you have the situation of the disabled returning veteran. Much like anyone else with a disability, there is a duty to accommodate. So employers can be required to provide both physical types of accommodation and potentially other accommodations, for example, training or things that would allow that returning veteran to slide back into the escalator position or a position of like seniority, status, and pay. Now, there are a few exceptions to the reemployment obligations beyond just those things that automatically disqualify the veteran, those dishonorable discharges, the more than 5-year limit, the failure to timely reapply. There's some other specific exceptions for employers, and those are listed here. One exception to the reemployment obligation is if the employer has some kind of changed circumstance which makes reemployment impossible or unreasonable. And the sort of obvious and frequent example is that the returning veteran's job was eliminated as part of a RIF, or a reduction in force. If the job is no longer there, then that would be a situation where you would have an exception to the reemployment obligation. Another exception is undue hardship, where the employee isn't qualified for the position and basically cannot be accommodated in such a way to make them qualified for the position. That's also another explicit exception to the reemployment obligation. And then the final one is where the position that the veteran left was a temporary position, and there wasn't any expectation on that person's part that they were going to be a continued employee with the company. If the position was truly a temporary position, that information was communicated to the employee, then that employee has no real expectation of coming back to work upon return from military leave. And with that, we'll go into some other rights that USERRA provides for returning veterans.
Okay, thanks, Carmen. You earned a break. A lot of employers don't realize that for a period of time after the service person returns from service and comes back to the workplace, even in our at-will employment states, that person has an extra protection, job protection. They cannot be discharged except for cause. And that protection applies for 6 months if they were out on service leave for 31 to 181 days, but it applies for a full year upon their reemployment if they've been out on service leave for more than 181 days. And the regulations give us a little bit of guidance on what is meant by for cause, but I think all employers have an intuitive sense of this, and what the regulations say is that if the employer is going to discharge this returning employee during the time period that they've got the for-cause discharge protection, the employer would have to carry the burden of proving that it was reasonable to discharge the employee for the conduct in question, and that the employee had noticed that the conduct would be cause for discharge. And so, you know, in the silly extreme, terminating somebody's employment for littering in the parking lot where they threw some gum wrappers out the car window is not likely going to be upheld as a reasonable basis for discharge. Everybody that has worked with labor agreements and the just cause standard realizes that implicit in the reasonableness analysis is the notion that the very extreme penalty of getting fired has to be reasonably related to the severity of the offense. It has to be something that was some serious misconduct that, you know, undermined the important business interests of the employer. And if you don't have that, you probably don't have a for-cause reason that would justify a termination of somebody in this job-protected period of time. Okay, let me move this forward. Also, upon reemployment, even apart from escalator position concepts, the returning employee is entitled to those benefits that are seniority-based as if they hadn't gone out on leave. And now an easy example to understand that would be perhaps vacation allotments or entitlements. Perhaps you have a 2-week vacation benefit until somebody hits 5 years of employment where they get a 3rd week. And at 10 years of employment, they get a 4th week or some such thing. Now, if the individual was out on military leave when he or she would have passed one of those milestone dates, the 5th year or the 10th year anniversary, when they come back, you have to treat them under this hypothetical as if they had worked the whole time and they had passed the milestone, and now upon reemployment, they're entitled to that extra week of vacation, just as they would have been had they not gone out on leave and just continued working right through that milestone anniversary date. Also, similar to what I discussed about the rights to benefits when they're out on military leave, upon reemployment, the individual still has to have, with respect to non-seniority rights that aren't measured by time served for the company, but on some other basis, these individuals are entitled to the same non-seniority benefits as anyone else who would have been out on a comparable type of leave of absence, even if it was non-military. And so again, my profit sharing bonus idea, you know, you couldn't deny the returned veteran last year's profit sharing bonus on the basis that he or she was out for 90 days in military service if you in fact still allow people who were out for a period of time on a medical leave to participate in the profit sharing bonus. So anyway, it's similar treatment for different types of leaves is the lesson. USERRA, of course, as an employment law, provides for certain remedies that individuals can obtain if their employers violate the law. And when Congress passed this law, it really modeled the remedy provisions after those that we find in the Fair Labor Standards Act and the Family Medical Leave Act, not like the remedies that we find in Title VII and ADA. Title VII and ADA, for example, allow people to recover compensatory damages for emotional harm and punitive damages, and you don't find that in USERRA because it's modeled after the FLSA remedies. What you find is people can, first of all, they could get injunctive relief that could be a court order requiring an employer to reinstate the individual if the employer violated USERRA in a discharge or a refusal to reemploy situation. And then on economic damages, it's basically focused on back pay, lost wages and benefits. And if the decision maker decides that the employer engaged in a willful violation, the back pay can be doubled. That's the so-called liquidated damages. Like every employment statute at the federal level, if the individual proves the employer violated the employment law, they're going to be entitled to have their own attorney's fees paid by the employer. And I think it's particularly unique in the USERRA statute that there's no statute of limitations. These claims can be brought years and years later, which is a real challenge for an employer to defend a claim that may be many years old because your evidence, your witnesses, your paperwork, your documentation, all the things that you'd need to successfully defend against the claim by way of showing a legitimate non-discriminatory reason for your behavior, it's really unlikely you're going to be able to compile all of that in relation to really stale claims. I mean, contrast that with Title VII, which requires people to file their charge of discrimination within no later than 300 days after the adverse action to preserve their Title VII claim. And that's Congress recognizing that, hey, the best time to address the issue, in fairness to everybody, is soon after the events in question, but not here. So this requires particular attention in that regard. You're wise to over-comply because it's going to really be difficult 4, 5, 8, 12 years from now to carry a burden of proving that you complied when you made some particular decision. And the last thing I'll say about remedies is reported in the trade press, the employment law trade press just today, the Federal Court of Appeals for the Second Circuit, which governs New York and other states up in the Northeast, today just affirmed an award from a trial court on a USERRA claim, and an awarded an Air Force reservist $926,506 in back pay. This particular person was a financial advisor who was paid on commission by a financial services firm, and upon coming back from military service was not reconnected with his prior clients that he had built up, obviously goodwill business relationship with, but instead assigned to clients who apparently had, or future prospective clients, and he had to do some cold calling and he had to build his business back up as a financial advisor paid on commission. He obviously had an argument that, hey, he really lost the compensation that he had built up and entitled himself to prior to going out on military leave. At the trial court level, he won his claim, and the appellate court just affirmed it. And so there's a very recent example, as recent as the last couple of days here, of somebody essentially winning $1 million on a USERRA claim. That is USERRA in 25 minutes or thereabouts, but we want to be sure to also talk about the other federal laws that impact and have some connection to military service. And with that, I'll ask Carmen to pick up on FMLA.
I just want to jump in shortly for our New York attendees. The web conference verification code is 36539. Thank you.
Okay, so with respect to the basics that pertain to folks in the military or family members of people who are in the military, we're going to sort of run through some of the basics here. As most of you probably know, several years back, I guess we're almost I guess we are 4 years now, back in 2008, President Bush signed the National Defense Authorization Act, which essentially amended the FMLA statute and added the two new types of leave at the time, which were the two types of leave related to military service. Those two kinds of leave are the qualifying exigency leave and the military caregiver leave. Now, like I said, those first took effect in 2008. However, since that time, the government has, Congress and the various agencies that put out the regulations have been tweaking all kinds of different provisions related to these two kinds of leave. There were some additional amendments in 2010, and the regulations that go along with those additional amendments just were published earlier this year in January. So we'll talk a little bit about each of those items as we go through here. Starting with qualifying exigency leave. This type of FMLA leave is intended to allow family members of the armed forces, including your National Guard and Reserve, to basically manage their personal affairs while a service member is on active duty or when they have been called to active duty. Employees who are eligible for qualifying exigency leave are entitled to up to 12 weeks of leave because of any qualifying exigency, which we'll actually talk about what kinds of things qualify as a qualifying exigency. And it has to relate to the fact that the person's spouse, son, daughter, or parent is on active duty or has been notified of a call to active duty status. Military exigency leave is part of the 12 weeks per eligible employee per year. So if they're using FMLA for other reasons, it's part of that 12 weeks. And just a note here that son or daughter does include adult children, unlike other types of FMLA leave, the FMLA leave that you're familiar with related to serious health conditions, for example, which typically in most circumstances only applies to minor children. The military exigency leave is different, and when it applies to a son or daughter, it applies in cases of adult children. There are roughly 8 categories of exigency that qualify a person for this type of FMLA leave. These are listed here for you. There's short notice deployment. That's a 7-day limit on the deployment. Military events and related activities, child care or school activities, including providing care, making financial or legal arrangements, obtaining counseling, rest and recuperation. Currently, this is limited to 5 days of rest and recuperation, or post-deployment activities that occur within 90 days after the duty starts. And then sort of a catch-all category, additional activities that are related to active duty or the call to duty as agreed to by the employer and the employee. The second type of military FMLA leave is the military caregiver leave. This type of leave is available for a spouse, son, daughter, parent, or next of kin of a covered service member. And those people are entitled to a total of 26 work weeks, up to a total of 26 work weeks of leave during a single 12-month leave period to care for a family member who is a service member with a serious injury or illness. As I mentioned, it's available during a single 12-month period, and it's on a per service member, per injury or illness basis. This type of leave, in contrast to some other types of FMLA leave, does have to be counted from the date the leave begins, and employers are required to use a rolling forward year for this type of leave only. Some of you may recall that with other kinds of FMLA leave, the employer has the option to use a number of different kinds of leave years, either a calendar year, a rolling forward year, a rolling backward year. But with this particular kind of FMLA leave, employers have to use a rolling forward year. And then again, the employee cannot take more than 26 weeks during a single 12-month period. Couple of points regarding definitions that are important to military caregiver leave. A covered service member is now a member or a veteran of the armed forces, including a member or veteran of the National Guard or Reserves, who has a serious illness or injury incurred or aggravated in the line of duty on active duty and is undergoing medical treatment, recuperation, or therapy. This is important because originally when enacted, the military caregiver leave only applied to care for persons who were currently a member of these various military services. It's now, with the 2010 amendments and the corresponding regulations that came out earlier this year, it's been expanded to include veterans as well. As far as the serious injury or illness definition goes, it is different from what we otherwise use for other kinds of FMLA, the serious health condition definition. Serious injury or illness for purposes of this type of leave includes an injury or illness incurred or aggravated that renders a covered service member medically unfit to perform duties of that member's rank, grade, or rating. Next of kin is also a definition that's unique to this kind of leave. Next of kin for purposes of military caregiver leave means the nearest blood relative other than the spouse, parent, son, or daughter. And there's an order of priority if the service member has not actually designated someone as their next of kin. The order is, as you see there, it's blood relatives who have legal custody, then siblings, then grandparents, then aunts and uncles, and then first cousins. One of the interesting things about the next of kin designation is if the service member has multiple people who are at the same level of priority, so for example, if the service member has both a brother and a sister, all of them may take leave to provide care to that service member either consecutively or simultaneously. A couple of further points regarding the military leave categories. Like some of the other FMLA leave available, the spouses that are employed by the same employer can be required to share the combined 26 weeks of caregiver leave. Likewise, the military leaves can be taken intermittently or on a reduced schedule. An employee can be temporarily transferred to a position that better accommodates an intermittent schedule. There are likewise the same substitution of pay provisions as what you might be familiar with related to other types of FMLA leave, and generally there are the same notice requirements. I've mentioned a couple of times the proposed amendments. The amendments themselves actually took place in 2010, but as I said, the regulations that implement and interpret those amendments just came out earlier this year. Basically, the amendments provide some expanded coverage for military service members, and then there's some additional coverage for airline crew members and their families. Specifically, the new amendments allow caregivers of military service members to apply for FMLA leave for up to 5 years after the service member leaves the military. Previous to the amendments, you could only apply for leave while the service member was currently serving in the military. Now, family members can apply to use FMLA leave to care for that service member for up to 5 years after that service member is done with their service. In addition, the new amendments increase the time that a family member of a service member can take off work to spend with a service member who is on rest and recuperation. You heard me mention earlier that the initial limit was 5 days. The proposed regulations currently expand that to up to 15 days. In addition, the hours of service requirement for flight crew employees has been made explicit because flight crew employees aren't always in the air but are otherwise working. They establish a different threshold number, 504 hours as opposed to 1,250 hours to be eligible for FMLA leave. And then there's some other technical changes that are included in the proposed regulations, things related to record keeping of FMLA documentation in light of the Genetic Information Non-Discrimination Act that came out a few years ago. These proposed regulations, for example, make it clear that FMLA paperwork that contains family medical history or other genetic information does need to be kept confidential and be kept in a separate file. There's some language related to the physical impossibility clause whereby the Department of Labor is making it clear that if you're making someone take an additional period of time off and you're claiming that you can't return them to work because it's physically impossible to do so, they're making sure that that's truly the case. The example would be if you did in fact have a flight crew employee who requested some shorter term period of leave, and by the time that leave expired, a flight that they were scheduled to work on has already taken off, it's physically impossible to return that employee to leave when they're to work when their leave completes because the flight is gone. That really is a physical impossibility situation, and the regulations are just making it clear that physical impossibility doesn't mean it's inconvenient for the employer. It really does have to be impossible. And so with that, we'll talk about some other laws.
Thanks, Carmen. And I note that we're at the 1 hour mark of our scheduled 90-minute presentation. We have, just so everybody can plan, we have only a few more substantive slides, and we're going to be able to wrap up early here. So I thank you for staying with us for this hour already, and just ask you for another 10 minutes or so of your time. We appreciate that. That's valuable. I thought that we needed to remind everybody about the amended and expanded ADA when we're talking about employing military veterans and their rights in the employment context. And that's because we do have data about service-related disabilities that now take on additional meanings and protections with the expanded ADA. The amendment went into effect in January of 2009, and we've really seen the impact of it already. In effect, the amendment broadened the scope of the statute's coverage. Congress, even in its writing, expressed real unhappiness with a series of Supreme Court decisions that had, over time, narrowed the application of the FMLA. What was a serious, what was a substantial limitation? What was a major life activity? And all of these terms of art in the ADA were litigated and interpreted ultimately in Supreme Court decisions, but in a way that really narrowed the usefulness and application of the statute. And so Congress threw all those out in the amendment and essentially said, we're going back to basics. We meant for this statute to apply very broadly to a broad range of physical and mental conditions that impact people's life activities, defined broadly. And really the emphasis of the statute shouldn't be on whether somebody fits into the protection of the ADA like the court decisions had all focused on, but instead almost assuming that most conditions do fall within the ADA protection. The focus of the statute is, so what are the employer's obligations in terms of what do you do about it? And of course, you engage in an interactive process with your employee, and you explore ways to accommodate that particular limitation, providing some form of accommodation that's not an undue burden on the business, but allows the individual to perform the essential functions of the job. A couple of ways that the amendment expanded the statute are interesting to me. One that is almost impossible for employers to deal with, I think, is that Congress tells us in the amended act that when you evaluate an employee's physical or mental condition and you're making an assessment as to whether or not it's a substantial limitation in a major life activity and therefore a protected disability, you do not consider how the person lives and behaves when they are assisted by some mitigating measures like medicine or a medical device, a prosthetic, whatever. The person's condition for purposes of ADA analysis now has to be considered in its untreated state. And so if I have an epilepsy condition, for example, that is really well controlled and really not a problem in my life when I'm consistent with my medication, still I'm now protected under the ADA because if I were not medicated, the likelihood is that this seizure condition would impede on my life activities. But employers really aren't in a good position to be making judgments about how bad would this be for you if your condition were untreated. That's really a difficult spot to be. But Congress isn't really worried about that in the amended act because the gist of the amended act is really most physical and mental conditions that impose some limitations on somebody's life activities are going to be covered disabilities. Things in remission now, Congress says. A cancer in remission, that's a protected disability. Episodic ailments that only rear up and really cause any challenges or concerns for the individual every once in a while, they're now protected disabilities. And so employers need to appreciate that, and especially when dealing with veterans that present some physical or mental condition, have to be really cognizant that our obligations under ADA are broadened, and we have to get past kind of a nitpicking analysis about whether somebody's condition is bad enough, and the law tells us that we've got to get more quickly into the analysis of, so what do we do about it? And what can we do that allows this person to maintain their employment and perform the essential functions of the job. And as we all know, that can be particularly challenging with respect to the mental disabilities. Somebody has the lifting restriction because of a back problem or something, and we all can figure out in most jobs ways to deal with that and accommodate that, and it's harder when you're talking about anxiety and depressive conditions that impact somebody. But still, that's why HR professionals get paid the big bucks, and employee relations professionals add value to their companies. Our obligation under the law now is to be more accommodating for more types of physical and mental conditions. Carmen?
Yes. In addition to the ADAA, we've got the Vietnam-era Veterans Readjustment and Assistance Act. This is a law, and there are corresponding regulations, of course, that require most federal contractors and their subcontractors to take affirmative action to recruit and to employ and to advance veterans in employment. As of right now, and historically, the Vietnam-era Veterans Readjustment and Assistance Act has been, in a lot of ways, a paper exercise. Federal contractors have been required to prepare an affirmative action plan and required to make some efforts to show that they're reaching out to veterans. But in recent years, the OFCCP, which is the agency that ultimately reviews federal contractors to make sure that they're complying with all of the laws that regulate federal contractors, the OFCCP has been really focused in on affirmative action for veterans as well as persons with disabilities. Current requirements with respect to veterans, federal contractors and their subcontractors are required to list nearly all of their employment openings, with the exception of very temporary positions, positions that are only posted internally, and tip-top executive positions. with the exception of those kinds of jobs, federal contractors and their subcontractors have to list all of their employment openings with a state employment service. In addition, they have to report every year on the number of current employees who are covered veterans. Those are the current requirements. Those are the current things that federal contractors and their subcontractors have to do. But with this increased focus, the OFCCP is proposing to require federal contractors and their subcontractors to do a number of additional things. For example, the new proposed rule that's been put out by the Department of Labor would require federal contractors and their subcontractors to establish actual hiring benchmarks for veterans. Right now, there's no requirement as to any certain percentage of veterans that have to be employed by federal contractors. But under this new proposed rule, the OFCCP would be looking to require federal contractors to establish those kinds of percentage-based goals based in part upon the availability of veterans out there in the workforce. Again, this is something designed to address those high numbers of unemployment that we talked about very early in the presentation. In addition, the OFCCP wants to impose greater record retention requirements. They would want federal contractors and their subcontractors to retain records about veteran referrals that have been received by the contractor, and they'd require that those records be kept for up to 5 years. They impose an annual review of personnel processes. Right now, the regulations simply say that federal contractors are required to review their personnel processes, so their processes related to hiring, promotion, demotion, termination. They're currently required to review those processes, quote, periodically, and there's no specification about how often periodically means. The proposed regulations would impose a requirement that review actually occur every single year. In addition, the proposed regulations essentially propose to create new veterans outreach and recruitment requirements. Right now, federal contractors are sort of it's left up to the contractor as to what kinds of good faith outreach efforts they're making. This proposed rule would actually propose to specify certain kinds of activities that federal contractors would be required to engage in terms of outreach to veterans. So big changes coming in the area of employment of veterans with respect to companies who are federal contractors or subcontractors.
You also may have heard in recent months about the Vow to Hire Heroes Act signed by President Obama. Largely, this provides different types of benefits to veterans and isn't directed right at employers. But there was an interesting twist in it that caused me to want to include it in our presentation. I mean, basically, it adds some transition assistance, adds some educational assistance by extending the GI Bill, provides for some extra voc rehab for disabled veterans, and some of these veteran-specific benefits that you might expect from the Act. But the twist is that it amended some language in USERRA that had been interpreted by a federal court to preclude a workplace harassment claim based on status as a military veteran who took a military leave. Basically, the court in that particular case was looking at what the type of discrimination that USERRA prohibits, and the court said, well, it doesn't have that phrase that we find in Title VII about other terms and conditions of employment, which was the phrase upon which a Supreme Court decision said, you know, Title VII not only prohibits specific discriminatory acts like firing somebody because of their race or gender, or religion, national origin, et cetera, but also the perpetuation of a hostile work environment that deprives them of the fair opportunity and equal opportunity to perform at work, and that's how harassment claims were born. They're just a variation on a discrimination claim, a different type of discrimination, treatment in the workplace. And that phraseology wasn't in USERRA, and the court said, well, as a result, I can't allow a workplace harassment claim under USERRA. And in the Vow to Hire Heroes Act, Congress, in addition to providing these other benefits, tweaked the language of USERRA to now include the magic phrase that allows people to pursue hostile work environment claims as a form of discrimination that's prohibited under USERRA, not just refusal to hire me back, reemploy me, or termination claims, but also, workplace harassment kind of claims. And the last comment I'll make about USERRA that's really worthwhile for employers to recognize is that it does provide for individual liability for the particular manager who had the decision-making authority and is proven to have acted in violation of the statute on a bias against the individual that took a military leave. And so, just when you're talking about people that are making those kinds of employment decisions just for in addition to compliance and all the other good reasons, this is a statute that allows for a direct claim against not only the company as employer, but that particular manager that made the allegedly discriminatory employment decision. We wanted to make you aware of a variety of resources that you can access, and there are more. I mean, I was just surprised as we did the research for this presentation. There's lots of resources, lots of help out there in terms of connecting with veterans and potential job candidates. If you're doing and considering any recruiting of veterans, here's a list of websites that provide a lot of useful information. The Department of Labor has a real nice section on their website for compliance with USERRA and some of these and the FMLA provisions and the like. And so if you need some guidance again in that regard, that's a good place to find those. And then the website at the bottom of the page as well. And I don't expect everybody to be writing these down. When we wrap up here, our colleague Kristen Martin can tell us where people can access this slide deck, and you can just print off the screen for yourself rather than try to scribble these down. But the last thing I'll mention is, in addition to those resources for employers that I showed on the last screen, there's also a wealth of information out there for returning veterans. And so if you have a family member or friend or employee in your company that is returning from military service and seems to be in need of some direction, not just employment law-wise, but transition benefits-wise and the like, here are some of the better resources for service persons. And with that, we'll conclude the formal presentation. I know from Kristen that we had a few questions submitted, and because we are in advance of 1 o'clock, why don't we go ahead and consider those, and Kristen, can you bounce those off us, and Carmen and I will try to answer.
Absolutely. The first question is, it was in regards to one of your previous slides, are these various tax credits cumulative?
Unfortunately, I can't answer that. I've just got some very basic information about the kinds of tax credits that are out there. That is definitely a question that you would want to pose to, again, your tax advisor or your tax attorney to find out whether you can take advantage of credits on top of credits with respect to any particular hire.
And then there's a follow-up to that. Is there still a general discharge? If so, does getting one disqualify the veteran from reemployment?
I think it's only the dishonorable discharge that disqualifies the veteran from the reemployment rights. And so if there is a general discharge, which I had learned about some time ago in the past as being so it's neither honorable nor dishonorable. It's the agree to disagree kind of walk-away discharge. I don't know if the military is still utilizing that category of discharges, but my sense of the USERRA rights is even if it is and it's not a dishonorable discharge, that USERRA rights would apply. Carmen, do you have any different take on that?
No, that's the correct. The regulations specifically state that they can't have a dishonorable discharge. Anything else would be acceptable.
Okay, how quickly must the employer return the veteran to work after the veteran applies for reemployment?
I can take that one. That is going to depend somewhat on the circumstances involved in the case. Obviously, if we're talking about a short-term leave where they're gone for a couple of weeks, there's really no reason that they can't come back to work right away on their next regularly scheduled work day. By the same token, if it's a longer-term leave, obviously it's understandable if it takes a little bit longer to make the arrangements to get them back to work. But the regulations do say, absent unusual circumstances, it's typically expected that the employee will be returned to work within 2 weeks after they make timely application.
Okay. And Kristen, where can our participants access the slide deck?
It will be up hopefully by tomorrow at foley.com/IW.
Inner workings. Okay. Mm-hmm. Good. Yeah, and I urge everyone to take a moment to look at the newly rolled out Foley and Lardner website that a lot of folks here worked long and hard on. Thank you again for entrusting a chunk of your time to us. I hope that we delivered some value to you in exchange for that, and we would very much appreciate if you took a moment and completed the survey form because we want to know how to do this better and be more effective in this somewhat strange topic of talking to a large crowd, none of whom you can see. And if you have any suggestions for me and Carmen, please feel free to add them.
Okay, thank you all. You may now disconnect.